If you've got a question for us, it is time to do legal lowdown now. Many legal issues, of course, don't begin in a courtroom, and they begin during some of life's most difficult moments when families, I guess, are trying to make decisions about aging parents or concerns about how someone's finances or care are being managed. If this sounds like this could apply to you and you have a question as well, I'm joined in studio by our Attwood Marshall Lawyers Estate Litigation Senior Associate, Duncan MacDougall. Good afternoon to you, Duncan.
Thanks for having me again.
The number here is 133 In Queensland, there's a specialised tribunal that's designed to deal with these situations, and it is the Queensland Civil and Administrative Tribunal. It's better known as QCAT. How important is the role, I guess, of QCAT, and what don't people really understand about what QCAT is?
So QCAT is, I tell people, it's kind of your layman's court. So it's meant for the everyday person. It was created in a sense where it was going to be a little more accessible rather than bogging the courts down with these sort of civil matters such as consumer matters, tenancy disputes, debt recovery, things like that, and administrative and guardianship issues around enduring powers of attorney, etc. They've created this tribunal where the everyday person can come forward and these sort of matters can be resolved in a tribunal space rather than a formal court setting. So although decisions can be made by QCAT and then just as binding as a court is making those decisions, it's created a little less formal process than you would before court.
So you have arbitration and it's all legally binding. But what is it meant to take, I guess, the legal burden or the burden out of the legal system?
Yeah, essentially. It's meant for your everyday person, person to come forward and say, hey, listen, for example, you got an enduring power of attorney dispute, whether there's concerns about the actual validity of the document themselves, or perhaps who should be actually dealing with the administration matters. So who's dealing with mom or dad's finances when they've lost capacity?
Right.
Who's making the healthcare decisions? Do they stay at home? Do they go into care? Things like that. Generally speaking, it's a lot of family quarrels that come before QCAT, and everybody's got a mountain of evidence there. But their general principle is to protect the person who's made the enduring power of attorney, or the person that we're talking about the finances for. So it's really coming back to, it's a lot of he said, she said situation.
Yeah.
But a lot of times that's what the tribunal is there for. It's to come down to a decision making platform where for a tribunal member is to make a decision on who's best appropriated to be in that role.
Does it exist within the legal system because those matters are somewhat trivial or are very personal?
Somewhat, yeah, and I think it's more of an opportunity, and I think that's exactly it. It was meant for to take the burden off the courts is the biggest one, I would say, but a little more accessible as well, rather than going through solicitors.
Yeah,
it's meant for the accessibility of anybody who's prepared to make an application through QCAT.
And do you find that people represent themselves?
That's generally what this process is for, even
to avoid engaging a solicitor or whatever.
Exactly, and the ongoing costs. It's meant to be a cheaper process as well. Okay. I mean, once you get solicitors involved, the costs do run up. But generally speaking, even if solicitors are engaged, solicitors still need to ask leave to appear on behalf of somebody. So it's meant for the everyday person to appear. Generally, more complex matters warrant a solicitor's involvement. In general situation where QCAT will allow those sorts of matters to be represented, but in most cases, that leave has to be applied for.
Okay, so then what kind of situations would you typically end up at QCAT, particularly when we're talking about, an aging parent or loss of capacity? What sort of cases, do you call them cases when they go to tribunal?
Yeah, we can call them cases. It's generally speaking, especially in our area in the estate and wills and estates space, you're dealing with a lot of administrative and guardianship applications. So where you have somebody who during their estate planning failed to acknowledge the importance of getting an enduring power of attorney in place, and all of a sudden they've lost capacity, somebody has to make these urgent financial and personal and health decisions on their behalf. In which case, these urgent applications can be made to QCAT in order to have somebody appointed, whether that be a family member, a third body, or in some cases where there's an impasse about who's best appropriated, quarreling siblings, etc. The bottom line might be the public trustee or the public guardian might be where it eventually ends up with. So those sorts of things. There's also issues about the enduring power of attorney document itself, whether it was validly created. Maybe they had lost capacity. I've had situations where somebody's pulled somebody out of a nursing home, prepared a new document. All of a sudden, this new person is administrating these matters for them,
right,
when they really didn't have the authority to enter into that document because they didn't have the requisite capacity. Those sorts of things, which then reverts back to any previous enduring power of attorney, or again, public trustee, public guardian, things like that. Or you may even have situations where you have an adult child who's had a disability for a number of years. All of a sudden, they're now over the age of 18. They do have a parent and a guardian, essentially, but somebody in to deal with those finances for the adult, that parent still needs to be appointed as the administrator for their child.
I guess then, can control ever be taken without QCAT's involvement when it comes to things with someone who loses capacity, or who actually has authority to make decisions about their finances or personal matters? If someone does lose capacity, can control ever be taken over without QCAT's involvement and without solicitors, without going down a legal line?
Yeah, it all depends on really that capacity of that person. So
Right.
there's instances where people go in and out of capacity. So at one stage, they may have a validly appointed attorney acting for their finances.
Yeah.
And then per a doctor's report comes back and says, well, actually, they are now able to administer their own finances. All of a sudden, they look through transactions and there's dodgy things about property being sold from under them, certain transactions on a bank statement showing it's going into some individual accounts, some dodgy things that have happened. All of a sudden, that's action that they can take personally as the principal who's prepared that document to say, well, wait a minute, I know I was incapacitated for a period of time, but these transactions are not authorized. I not necessary. In which case, these sort of things can be clawed back into their estate at that point in time. So it can get pretty messy.
Wowza. It's curious to me that QCAT exists as a step before, I guess, litigation, or, before solicitors become involved in situations, especially when it comes to matters with family. Sometimes you do need to have that arbitrary third party to help you navigate this. Are there any formalities or anything that you've got to follow when you apply to have your situation heard through QCAT?
Yeah, it's a less formal situation.
So I don't have to wear a gown if I have to represent myself?
Wear a gown, no.
Can I wear a wig?
You're welcome to if you want to.
No, but I want like a judge's wig.
Yeah, go for it. You might look a little more important. But no, it's meant for that everyday person, and it's meant to, and again, they're going to take into consideration the history of who's been taking care of them, a bit of the family dynamic, where they're living, where they're residing, all these different things, and again, the history of who's been managing their finances to date. Have they been doing it appropriately? Who's best are they close? Do they reside closely to the principal? All these different factors will go into it. And generally speaking, it may not be completely affidavit material. It may not be affirmed material, but it all comes before the tribunal to say, okay, here's one side versus another side, rather than your formal court setting where it's, okay, this affidavit has to be prepared in this certain way, with legal advice, and only a representative can appear on your behalf.
What I'm hearing is, like, if you're in a family dispute, or if particularly if it's around estates or capacity or whatever, often these situations come with a lot of emotion. And I would imagine that anyone who fronts up to QCAT with a mountain of evidence, the evidence is probably based more with the heart than with the head. How much is too much evidence, and what sort of evidence do QCAT rely on in those sorts of situations?
Yeah, well, we're seeing now delays at QCAT. So what used to be a more of a quick process, you're seeing before a hearing date is set at QCAT, months in the making, because I think a lot of people, through the use of AI now, for example, people are throwing their case into AI and all of a sudden generating a mountain of material before the tribunal, which really is just more of a detriment than anything to them, because at that point in time, they've got all this mountain of material that they're dealing with here, and they're just getting bogged down. So there's a lot of just procedurally wise there as well. We've got situations where urgent applications have to be made, yet you don't have a hearing date set for 4 or 5 months in advance. There may be some sort of interim hearing where an immediate decision has to be made. In those cases, perhaps the public guardian or public trustee are appointed as an interim person whilst they deal with the squabbling family behind the scenes.
Wow. Because of the backlog, because of the fact that people are playing PI or, whatever, being their own lawyer. Really?
So again, it's obviously getting a lawyer involved can try to mitigate that and realize, okay, this is really more the important things to come forward. And this is where people like engage, for example, us to represent them, especially if it is a little more complex and there's a mountain of issues that have to be identified.
Yeah.
Generally, those sorts of applications can be made by a solicitor on their behalf. Just to consolidate information and try to keep things moving along procedurally the way you want them to.
Yeah, well, I'm making sure that you have the relevant information as opposed to mounting cases based on AI technology. I cannot believe that people would do that. Wow. And like I said, it does feel like it's matters of the heart. It's, most of the time, when I've had experience of family members that have, and money will do that. It will tear families apart because they don't agree, or perhaps the care over a parent.
I think a lot of it too is people forget that the interest here is the principal, the adult here that we're talking about.
Yeah,
they come into play all these sort of their own personal objectives on what they want best to happen. But really, it's what's best for the principal. In the whole, if you take an objective out of all of this and taken from an objective viewpoint, what's the best option here for the adult?
So QCAT could very well be the answer if that's your inability to see through that, I guess. QCAT could be the answer there.
Yeah, and in that case, they may appoint the public trustee and public guardian as that independent third party, whereby they take the family outside of it because they're at an impasse.
And whatever, I don't know if it's called a ruling, but whatever judgment they come up with is legally binding as well.
Once those orders are made, yes. And those orders will be reviewable after a few years as well. So they may be reviewable after 3 or 5 years, in which case the parties can come in again. Again, generally, the public trustee and public guardian will generate reports as well. So things like that will come into play. Medical evidence will come into play. A lot of material comes before them. I'd hate to be a tribunal member, to be honest.
I was going to say, that'd be a lot to go through.
It's interesting to see where that space is going to develop over the next few years.
It is fascinating that there are all these facets of legality and law. I mean, I hope I don't have to go to QCAT, but we've usually just ended up in a courtroom. Duncan, thank you so much. Duncan MacDougall there, who assists us and families, I guess, navigating these matters as well. You can catch up with him at Attwood Marshall Lawyers as an estate litigation senior associate. We'll catch up with you again this time next week.
Great, thanks.